Ready? One, two, three, start. The learned judge, having assessed the oral and documentary evidence and pleadings, answered issue number 1 partly in the affirmative by holding that the father of the plaintiff, namely A. Venilal, was the absolute owner of Schedule A to D properties. The learned judge, while answering issue number 3, has arrived at a conclusion that Schedule C properties were purchased by Venilal along with his wife Srimati Jaya Venilal. The learned judge has come to conclusion that the parents of the plaintiff and defendants, namely Venilal and Jaya Venilal, had half share each in Schedule C properties. The learned judge, while dealing with issue number 4 and recasted issue number 6, has come to conclusion that defendant numbers 1 to 3 have established the due execution of will executed by late Venilal as per Exhibit D4 and the will executed by their mother as per Exhibit D7. The learned judge has recorded reasons that the defendants, to remove suspicious circumstances, have examined the attesting witness, that is DW4, and the evidence on record would clearly indicate that they have succeeded in establishing the due execution of the wills executed by their father and mother. On these set of reasonings, the learned judge has come to conclusion that Schedule A, B and D properties were the absolute properties of Venilal, and accordingly their father Venilal has effected partition as per Exhibit D3, and insofar as Schedule C properties is concerned, the parents have bequeathed their properties and the defendants have succeeded by way of testamentary succession. The learned judge has come to conclusion that since the properties are dealt with under partition deed as well as the testamentary succession, there is absolutely no properties available for partition. Accordingly, has proceeded to dismiss the suit. The learned counsel, appearing for the plaintiff, would vehemently argue and contend before this court that the finding recorded by the learned judge on issue number 2 suffers from serious infirmities and the same is contrary to the clinching evidence on record. Learned counsel would further vehemently argue and contend before this court that the plaintiff's uncle, namely Krishna, had filed suit for partition against her father in OS number 5783 1991. He would submit to this court that during the pendency of the suit, the plaintiff's father, namely A. Venilal, died, and the present plaintiff and defendants were brought on record as the legal representatives. The present plaintiff filed written statement wide Exhibit P2. He would further contend before this court that the defendants, who were also brought on record as legal representatives, did not set up will in OS number 5783 bar 1991. On the contrary, one of the defendant in fact filed an affidavit stating that the plaintiff and defendants are entitled for 1/4 share of Venilal. He would further submit to this court that the suit was decreed in part, declaring that plaintiff and defendants are entitled for 1/4 share in the suit schedule D properties. Placing reliance on the decree in OS number 5783 bar 1991 as per Exhibit P3, the learned counsel would vehemently argue and contend that the inter se rights, in so far as entitlement is concerned, was decided in OS number 5783 bar 1991, and in the present suit all that was required to be adjudicated was as to what would be the share of the plaintiff out of 1/4 share held by her father Venilal. This clinching evidence is not at all dealt with by the learned judge while attending issue number 2. The learned judge has answered issue number 2 in the negative. The said finding is perverse and palpably erroneous, and same is contrary to cogent and clinching evidence on record. Learned counsel would also submit to this court that the judgment and decree passed in OS number 5783 bar 1991 has attained finality, since the appeals filed in RFA number 563 bar 2004 and 332 bar 2004 ended in a compromise, and the preliminary decree passed in OS number 5783 bar 1991 was not at all disturbed, and the same would indicate that the preliminary decree passed in OS number 5783 bar 1991 has attained finality. The learned counsel would further vehemently argue and contend before this court that the learned judge has superficially proceeded to answer issue number 4 and recasted issue number 6 in the affirmative, which deal with the will executed by the parents of the plaintiff and defendants, and also recasted issue number 5, which deals with the alleged memorandum of partition set up by the defendant numbers 1 to 3. In so far as wills are concerned, he would counter the reasons assigned by the learned judge by specifically contending that the wills were virtually given up by the defendant numbers 1 to 3 in OS number 5783 bar 1991. Relying on this material aspect, learned counsel would submit to this court that the wills are shrouded with suspicious circumstances insofar as due execution of the wills is concerned. He would submit to this court that the legatee has not placed on record clinching evidence indicating due execution. From the several material aspects which would add up to the already existing suspicious surrounding of both the alleged wills dated 18/12/1997 executed by the parents of the plaintiff and defendants as per Exhibit D4 and D7. He would vehemently argue and take this court to the wills relied on by the defendants and submit to this court that signatures of the parents are found on both the wills and the pattern in which the signatures are secured would only indicate that same were secured on blank stamp papers. He would further submit to this court that though thumb impression is secured on Exhibit D4, the same is not at all identified. The similar pattern is also found in Exhibit D7, which is the will alleged to have been executed by the mother of the plaintiff and defendants.